One of the greatest assets of a company is the IP.
This is Ariel Dubinsky. He's the founder and owner of Ariel Dubinsky Law Firm in Israel. There, he specializes in intellectual property law, particularly in copyright and trademarks. Considering Israel saw a record-breaking $10.5 billion in startup acquisitions this year, understanding IP is more important than ever.
Sometimes a patent is not a good option for them, but the trademark is their commercial identity, so they realize that it's one of the most important things to secure at an early stage.
Welcome to Clause 8, presented by TradeSpace, a revolutionary end-to-end AI-powered IP management platform that helps companies unlock the value of their IP. If you enjoy this show, please take a minute to subscribe on clause8podcast.com for updates. Earlier this year, Eli was able to join Ariel in Israel and spend a day learning about his practice. Today, Ariel joins Clause 8 from Tel Aviv to discuss managing trademarks in the startup nation. And now, here's your host, Eli Mauser.
We're lucky to be joined by Ariel Dubinsky today. Through doing this podcast, I've learned about a lot of different practices that people have built in the IP field, and they're all very different and very interesting, and they all work somehow. And I've got to know about your practice in Israel over the years. It's a diverse practice, but earlier this year, I actually got to spend a whole day with you.
Yeah.
And although I don't speak Hebrew, it was just fascinating to see you kind of at work in Israel and how dynamic your practice is. So I wanted to share your story because I know I'm sure others will be just as fascinated as I was to experience that firsthand. So your practice mostly, I guess, focuses on the soft IP, trademarks, and copyright.
Yes.
You go to international conferences, you meet attorneys who do this kind of work all around the world. How is it similar or different doing that kind of work in Israel?
I guess it's pretty much the same as a U.S. attorney. On a daily basis, what we do, we're doing a lot of litigation cases. We're focusing on trademarks, trademark prosecution. We file trademarks in Israel locally and through the Madrid Protocol in the States and worldwide. We also engage local agents globally to file trademarks, patents, and design applications.
So interesting, just because you're based in Israel, the day-to-day isn't that different from what others are doing around the world.
Yeah, it's pretty much the same. Going to court, litigation, preparing the client for testimony. Pretty much the same practice, but we're based in Tel Aviv, Israel.
And Israel does have, Tel Aviv, you mentioned, it has a reputation of being very entrepreneurial.
Yes.
Sometimes referred to as the second Silicon Valley. I think I have a book, Startup Nation, somewhere behind me. I guess for people who aren't that familiar with Israel, can you tell us why is Israel such an entrepreneurial place? And then how does that impact your practice?
So I think it starts from, I guess, it's the Israeli mentality. A lot of startups starting at the Israeli army, a lot of guys coming from the intelligence units that dealt with the technological issues at the army. A lot of startups, a lot of high-tech. The government supports the high-tech industry, and things are very active and energetic here in Tel Aviv.
So it seems like it's a normal thing for people to do in Israel. If you do have a technological experience from the military, is to then be able to leverage it and share it in the commercial spaces. That kind of
Yes.
Yeah. Interesting. And one thing that I saw, like I said, you're getting calls all day from, I guess, potential entrepreneurs interested in trademarks. Some people are oblivious to the legal aspects surrounding starting a business. What do you think is motivating the ones that you do hear from? Like, it's motivating to reach out to you. Why do we start thinking about trademarks?
Yeah, in some cases, they start the process early. They understand the importance of securing their trademarks in advance before even setting up the company, the startup. They think ahead and file registrations locally and globally. That's the easy part. And sometimes they find an infringer. Someone infringes their rights and they remember to secure or to check the status of trademarks. And sometimes clients are sued for trademark infringement. And that's another option.
We'll delve into all of those. But first bucket of people To people who know to be proactive, what kind of makes them realize that's important?
I think they understand that one of the greatest assets of a company is the IP. It can be, of course, the patents, which are also super important, but sometimes a patent is not a good option for them. But the trademark is their commercial identity, so they realize that it's one of the most important things to secure at an early stage.
But, obviously somebody starting a business, usually they have minimal resources or they want to be frugal in the way they deploy those resources. And when you mention a global trademark program, that sounds expensive.
Yeah, it is expensive. My advice is to target and to secure. First of all, what I'm saying is that it's always a commercial question where to secure the trademarks. Sometimes when a client approaches me and tells me I'd like to secure the trademark globally, no matter what, I'm asking him what are the target markets, and then you need to decide where you wish to secure. That's the I think that's the answer for where to secure your trademarks.
Let's say somebody has, I don't know, very minimal resources. Would you ever advise, like, all right, hold off before you secure your trademark to see how your business is doing?
That's sometimes a good option. What we're saying is that having a trademark is a bonus. It's important, and it's much easier to litigate the case whenever you have a valid registration in court. It's a kind of an easy case, but sometimes you can use the non-registered, the reputation that you own, and you can enforce your trademarks, even if it's not registered. So the best advice is to evaluate the importance of trademarks, and also some markets or some products that the competition is quite low in terms of the brands. So it's not.
It's not as important. Is it, for example, like I imagine if you're starting like a company that's going to be mainly geared towards, I don't know, a defense tech startup, for example.
Yes.
It's been on my mind recently.
Yeah.
Your customers are going to be maybe the U.S. and the Israeli governments, then maybe it's not as critical as if it's going to be a customer.
Yeah, that's correct. But sometimes the infringer can use the reputation for other products that are not even similar, but misuse the reputation for its own purpose. But yeah, I think it's a good example.
Obviously, you mentioned sometimes you need to actually counsel clients not to spend too much money on trademarks, but I think it goes to the fact that when entrepreneurs start a business in Israel, they're not just starting it for Israel most of the time, at least in the tech space.
Yeah.
They have global ambitions, and you counsel them, well, where are you really going to go? But I guess, can you share that piece about, all right, you determine the markets. How does that piece of your practice work in terms of picking? Do you have like foreign counterparts that you send work to? How does that?
Yes, as you said, I'm attending conferences. I cooperate on, I would say, a daily basis with colleagues all around the world. In the U.S., we work with at least 20 different law firms, and we engage foreign clients whenever we have an office action or the client asks for a registration outside of Israel.
So I want to ask you about that. Obviously, there's foreign companies coming into Israel, and you're mentioning those that are pursuing trademarks, I guess, in Israel registration. But have you seen any issues where foreign companies start thinking about getting trademarks in Israel too late? And I guess what kind of issues do they run into?
Yeah, the issues that they run into is sometimes the foreign clients do not run a search before they secure their trademarks. In some cases, they already sell their products in Israel and then they start to secure their trademarks. Our recommendation is to secure the trademarks before entering a foreign market.
If you're not familiar with this, and in the patent space, people think, I have a trademark.
Yeah.
Let's say if you use LegalZoom or whatever, they get a trademark, they're like, I'm all set, but you need to get a trademark in every different registered jurisdiction.
And each and every jurisdiction, it's if you wish to enforce it in Israel, you need a local Israeli trademark registration.
So what happens, like in that example that you shared, for your clients, let's say they're just thinking about a business, and they come to you and they say, we want to get a trademark for our brand. And at that point, you do a search, and you might advise.
Yeah, the best option.
Something different.
Yeah. First of all, the best option is to start with a search before getting into costly applications, prosecution, and so on. We advise them to run a search. It can be a cursory search on Google before paying us or engaging us, and then second phase is to have search in the Israeli trademark office. There's an examiner that checks for possible infringements, for possible citations of the trademark. We get a report, we analyze it, and we send it to the client for their review with the recommendations, the chances of success of securing their trademarks in Israel.
But when you do, I guess that's when they do the cursory search, do you recommend doing a search in each jurisdiction they might be interested in? Or first you apply for a trademark in Israel usually, and then based on that you kind of...
Yeah, so if it's an Israeli client, we tell them usually, let's say they wish to save costs. And sometimes running a search in the US might be even more costly than securing the trademark. So what we're telling the client is that 90% of the trademarks that are registered in the States are probably registered elsewhere in the world. So if they will not be able to secure the trademarks in the US, they will probably face the same issues elsewhere.
Okay.
Yes, so that's another option if they do not wish to run searches on other jurisdictions.
So that's interesting. The part about actually maybe getting the trademark is easier than
sometimes
doing like a thorough search.
Yeah.
So going back to the example, I guess, of the foreign company coming into Israel, let's say they were a U.S. company who was operating with a trademark. Are they ever surprised that
a third party is using their trademark? Yeah. I wouldn't say that they're surprised. It happens from time to time that we find that there is a local Israeli registrations that is cited against the registration of the applied mark from the U.S.
So what advice do you give at that point?
There are some options. Sometimes we can approach the other. It depends if the other party is doing the same, offering the same list of goods. We can try to get a coexistence with the other party. Sometimes we realize that the mark is not actually in use. So we engage a private investigator to check if the mark is in use for the past 3 years, and we can revoke the registrations. That's something that we did in the past as well. So it depends on the situation. And of course, we can argue against the similarity. Sometimes the examiners, in most cases, the examiners issue an office action which is not correct. We try to persuade, and we succeed in our arguments that the marks are not similar.
Is there ever a situation where none of those options work and where they have to, like, I don't know, what would they do? Would they have to get a separate brand in Israel, or how does that work?
Yeah, so before trying another brand, we can try to get a judicial decision, and then we can appeal the decision. But if everything doesn't work, they need to rebrand. They need to find a new brand to operate in Israel.
Yeah, and that seems pretty crazy, right? Just the complications that would cause for a business,
of course,
if they want a small market, which goes to think like, all right, as soon as you know you might enter a market, you want to start thinking about that. One thing I do know is that on the trademark space, there's companies with big trademark programs. They monitor everybody who's applying for trademarks, and then if anything is remotely similar to theirs, then
they
tell
file an opposition within seconds, automatically instruct.
If they threaten, and then they do it. Which is scary, right? For somebody who's like, all right, I'm just trying to start my business. What advice do you give to somebody facing that in Israel, and then maybe facing a similar situation, an Israeli company facing a similar situation in the U.S.?
Yes, whenever, and we're now representing clients that receive an opposition, which I believe is baseless. We tell the clients that it's a strategy to make them withdraw their application. We advise them to file a reply to the opposition and then see if they're really handling the case and getting into the costly litigation. So sometimes companies file an opposition, and whenever they get a reply, they withdraw the opposition. It depends on the situation and on the importance of the brand for the client. If it's a small entity, I wouldn't get into costly litigation, even if you're right. Eventually, the judge will not provide the actual cost. Even if you manage to win the case, it's quite a challenge to get the expenses back.
And is it significantly more expensive in the U.S. than Israel, or is it?
It's in the States, it's more costly. Although, if I compare the complexity between the litigation in Israel and the U.S., in Israel, the affiant is required to appear in the trademark office to be cross-examined on their affidavit, on their statement. And in the state, you're not required. So sometimes it gets costly in Israel as well.
In most of those situations where it's like they're stretching it, that company who's filing opposition, when you file a reply, do they just back off? Has that been your experience? Or
Yeah. In most cases, when we file a reply and they know that they don't stand a chance, they withdraw their position.
You know, in the past, with technology kind of monitoring this stuff and then sending these letters, you know, people would use lawyers,
Yeah.
which was somewhat of a barrier. Now there's all this, I guess,
AI.
technology coming to do that. Yeah, exactly.
Yeah.
AI. What is your thinking with that? Any startup can launch an AI to do that, right? To modern send out cease and desist letters. I guess, any thoughts about that? Have you seen an increase in this stuff? Does that concern you?
I'm not concerned personally. I think as a litigator, litigation will not disappear. I think the written summations will be much easier. I think the computer, the AI technology will provide us with a lot of options to write the papers. Besides that, I think applications will be also much easier.
I guess going back to the companies that I guess are maybe entering Israel, foreign companies, and knowing the system, you mentioned a little bit about the litigation there. I think when you and I talked, I think you said Israel is relatively litigious, I guess, compared to other places. Is there anything else, I guess, you think that a business coming through U.S. should know about the litigation system? But also, I guess I'm curious, in the IP area, I guess the bar is relatively small, right? I presume. How does that impact your practice?
I think one of the most interesting things about the law in Israel, that I think the copyright law in Israel is quite unique in a sense that copyright owners, as opposed to the states, are not required to file anything. As opposed to the US, we do not have a copyright office, and whenever we file a copyright claim, we only need to prove that we prepare the artwork ourselves, and there is a statutory there are quite huge amount of compensation awarded to the copyright owner in Israel without any registrations, and that's something that needs to be considered by companies entering Israel.
What is the statutory damage?
It's around $25,000 per infringement. The judge can award an amount of compensation in the range between $0 to $25,000 per infringements. So let's say we have an infringement of 4 artworks. Could be photos, could be text, could be any other content, videos. So it could be quite a huge amount of compensation awarded to the copyright owner without any prior registration. And also, as opposed to the states, you can't know in advance that this artwork is registered because we do not have any registration at all. We do not have any database of copyright in Israel.
So I know a part of your practice, which I found very interesting, is representing photographers who might be dealing with copyright infringement, somebody using their photos without permission. But I guess I'm curious about what counts as infringement. So let's say a website uses a photo. Is infringement just using that photo? Is that 25,000, or is it, I don't know, every time somebody clicks?
The photographers, of course, would like to hear that whenever you use it, it's the 25,000. But that's the higher amount. That's So it's somewhere in the range, mostly closer to the 0. But still, it's a threat. It's a threat to someone who misused the artwork.
Oh, interesting. So there's a range that the judge can set between
the judge, there are several factors depending on the length of the infringement, how long was the artwork was used, if it was commercial, not commercial, what type of commercial, type of infringement.
Let's say a U.S. company that has a photo on their website. Do they have to operate in Israel?
Yeah, so
I
they
guess-
need to operate. Yeah, I think the connection is that, let's say, if they infringe a copyright of Israeli entity, that's what might be possible to litigate the case. That's the link to Israel. The case must be linked to Israel, otherwise we will not have the jurisdiction.
The copyright owner should be in Israel. And I'm just curious, do you remember the first case you ended up handling where you were representing a photographer? How did you end up doing that?
How did the client found me and how did it start?
Yeah.
So before I opened my firm, I worked at the largest firms and I dealt mainly with trademarks. I knew that there is a big market of photographers, but I was not really interested and I wasn't really aware of the field. And one day a client called me and told me that he was invited to a wedding and the owner of the arena suggested that he will use his photos without any cost, but will provide him credit, meaning that he will say whenever the photo is displayed that he's the photographer. And he realized that he didn't receive any credit, and we filed a lawsuit, and it was a big case, and the judge awarded I think it was 50,000 new Israeli shekels, which is 15,000 US dollars. And then another client came, and then another one. So that's how it started.
You said 25,000 is like the max.
Yeah.
What is like the typical user?
Yeah, so I have a good example. I just litigated a case. I represented the other party, the defendant. And in this case, we had two e-commerce websites that the plaintiff produced some sort of a video that presented the product in question. And the judge and my client, the defendant, just copied the video for its own purpose. The judge awarded 40,000 new Israeli shekels for the case. Yeah, so it's about 40% of the highest amount of statutory damages that can be awarded.
And I guess that's interesting. Like in that case, the other party didn't want to, like your client didn't want to settle.
Yeah, so we tried our best to settle the case. Unfortunately, they asked for unreasonable amount of compensation. We also went to mediation, and they didn't work out. Eventually, like in 90% of the cases, the case was promptly settled at the first pretrial hearing. Within 20 minutes of a hearing, the judge said, "Okay, the case ends today." That's it. I do not recommend to litigate this case until final judgment. I get the idea, and he suggested a range that he will render a decision between 10,000 and 70,000. We agreed, and he came back with a judgment of 40,000.
I guess similar to yes, it helps when the judges
Yeah.
for settlements from both. I'm curious, do photographers, do they use, I know there's software that kind of scrapes the internet?
They use a software. Some of them use Google Images to locate their photos, which is for free, and some use a software that was designed to locate infringements globally. There's a very successful Israeli startup that offers cooperations with photographers to locate their infringements worldwide.
Does it matter if the infringement is willful in terms of, like in your first client, where that venue owner knew he was taking somebody's photos and using them versus somebody just taking something off the internet randomly?
Yeah,
does that matter?
Yeah, it does matter. What we're saying and what we're advising clients before we start any litigation, we're telling them that the logic behind the law is that the legislator wanted to award the statutory damages against a third party and not someone that you know, and not against your client. Let's say you work with a client and he didn't give you credit. The law in Israel provides that the statutory damages also are awarded in a case whenever you do not provide a credit. And in most cases, the judge is not awarding a substantial amount of compensation whenever it's not someone who's not a total stranger. So if you're trying to give a lesson to tell your client that he is going to pay more because he forgot to, I don't know what, to put a credit somewhere, it won't really work.
But I guess in terms of that third party, does it matter if the third party didn't know what copyright is, or
yeah, that's usually
like,
whenever we review the statement of defense, the defense arguments, they sometimes say, I took it from the web, I didn't know it's copyright protected, it didn't have any watermark, and so on. But these arguments are mostly baseless and are not really heard by the judge.
Oh, interesting. What advice would you give to potential businesses that are like, they have so many web pages and whatever?
Yeah, of course. So what I'm saying is that they should buy photos from image banks. It's much cheaper than getting sued or getting a cease and desist letter. Sometimes I advise them to use AI. You can create by yourself or use copyright-free photos or take photos by yourself. That's another option.
I know in the U.S., I guess with the copyright issues, have you seen it in Israel about AI generating something and then somebody saying, that's actually the AI used my art? And now this, have you seen any?
Yeah, also sometimes defendants argue that they did not really misuse the copyright, the artwork. They took some sort of AI software and received it and did some manipulation and they didn't know the source. It's a big issue, and still I know that in the States there is pending litigation in AI copyright matters. In Israel, we do not have any judgments in this field up until, as far as I know.
The one thing that I guess to me, correct me if I'm wrong, the statutory damages apply. They actually provide the ability for copyright owners to enforce their rights in a way that probably otherwise would have been very difficult. I know in the U.S., unless your damages are really high, nobody will even handle your case. And I think there's now a small claims copyright in the U.S., but I'm not sure how that's going. I'm guessing not that well because I haven't heard about it since it was created, but maybe I'm wrong. Is there something about Israel which a high respect for the creators, for copyright owners, that you think is there a reason why the law is favorable to them?
So there was some sort of, the Israeli legislators are aware of the problems in the statutory damages. We had some cases whereby photographers filed claims against Knesset members, against parliament members, and we did have it's not a new law, but it was a new section in the copyright law that canceled the statutory damages against individuals. I believe that the law is good, however, it can provide some misuse of the law by photographers in some cases.
But it also gives them an ability to reward it for their work as well. I guess that's a positive. Yeah,
of course.
Another thought, I guess you mentioned the link that you need to have is for a copyright owner to be in Israel, or I don't know if they have to be a resident citizen or create a art there. But in terms of enforcing against a foreign company, can you tell us how feasible that is within Israel? Let's say you operate only in the U.S. Is it?
So whenever a client approaches me and tells me that he found out that, let's say, there are infringements in the U.S. or in Europe, I usually advise them not to act and not take any actions other than if they wish to remove the artwork, the use itself. As far as I know, the litigation in the U.S. is costly and usually will not get a substantial amount of compensation, and even no compensation at all because they did not file for any copyright registration at the U.S. Copyright Office. That's in the U.S. And of course in Europe, as far as I know, you need to prove actual damages, which you do not have in 99% of the cases. That's the recommendations for global enforcement.
Another, I guess, in the copyright space, you actually wrote a very interesting article for IP Watchdog, which got traction about at the height of reality TV, I think, in the 2012. about whether reality television gets copyright protection. Can you tell us about how you got interested in that subject, and I guess what is the conclusion you came to?
Yeah.
And I guess
Okay.
what happened?
Yeah. So thank you for mentioning my article. It was, as you said, 14 years ago. I got the idea from a lawsuit. Back then, there was a lawsuit. Endemol, the producer of the Big Brother in Israel, found out that another Israeli TV channel is producing something which is some sort of a TV production, which is pretty much similar to the Big Brother. They filed a lawsuit that was at some point settled. And I wrote an article about the question if having some sort of a production like the Big Brother is entitled for copyright protection. I believe so. I believe there are elements that can be protected. I wrote about it in my article. And although I think they settled the case after, I believe, the statement of defense, but I believe that you can enforce your rights in TV productions like The Big Brother.
And I know the Hollywood Reporter picked up your article.
Yeah, that was great. That was amazing. Having an article, and within hours I got a call from a guy in Hollywood Reporter picking up the phone asking if he can quote me. It was quite a story, quite exciting.
Yes, there's obviously a lot of interest, but you do see this phenomenon, and I'm a fan of reality television myself when I had time, but
of course,
somebody creates a show.
It's the best.
Somebody creates a show, and then others create very similar shows. I guess in some ways it's reality television, right? It's just life. So I guess what would it take, from your perspective, what would the reality television need to have? What aspects would you be able to copyright protect?
So let's take another example of, does the Big Brother is aired in the U.S.?
Yeah,
Still going on?
But it's funny. I don't know. But it's funny. The Big Brother became popular after Survivor.
Oh, the Survivor, yeah.
Big Brother was international.
Yeah.
But it's the same kind of thing.
Yeah, the same.
People
yeah.
Get them, yeah.
So I think it's, let's say, if we look into the Survivor, it is quite challenging to find these unique elements because people are in some sort of an island, separated from their family, and they need to, they get some different challenges and they need to get awards for these challenges. I believe the scenario can be in some sense protected, but it is quite challenging because there are so many similar shows. In some sense, if we look into the similarity between Survival and the Big Brother, it's pretty much, there is both have you're not at home, you have the challenge to spend the time with the foreigner, people you don't know, and so on. Yeah.
Another famous, I don't know if there's an Israel, but franchise in America is the Real Housewives, right? So they just take a group of 6 or 7 women in a city, and then they follow their relationship. But the concept is, so these women and they're friends and they bicker in a city. It's something like that, because I've seen, obviously, it's actually a pretty clever concept if you think about it. Oh yeah, that makes good TV. But at the same time, it's not that creative, I guess. But I guess from your point of copying something like that, do you think that would be...
Yeah, it's going to be a challenge to stop this, something that will be similar. I totally agree. What was happening 14 years ago when the Big Brother, the situation that whenever the Big Brother started their shows 14 years ago is not the situation that right now we have so many similar, and in order to prove a case of copyright, you need to show that it's original, and so on. I'm not sure it will be so easy these days to show.
Interesting. Yeah. I guess it would have to be something unique.
Yeah, unique. Yeah.
One thing, I guess, back to trademarks, I guess I want to talk to you. When I was visiting you in Israel and I was getting to, it was very cool to be a day in the life of Ariel Dubinsky. It was a live reality TV show for me. It was very fascinating. And I think you got a call, and it was a Hebrew I didn't understand. But afterwards you said, it was somebody from I believe in the West Bank calling me about some trademark issue. And I was like, I was shocked because Israel was in the middle of war, and crazy with somebody from West Bank is, first of all, thinking to reach out to Israel about a trademark issue. Can you tell us about that part of your practice and the realities of practicing?
So, interestingly, cooperate with the colleagues from the West Bank. We cooperate them like any other colleague on a worldwide basis. We receive leads from them. We handle their clients' portfolio in Israel, litigate cases for their clients, and vice versa. Whenever we have an issue in the West Bank, we engage them to litigate the case. And it is quite challenging, of course, at these times to cooperate and to work with them. But we're friends for years, and we're doing good business together. Hopefully.
I mean, there's a lot of...
Also, what's interesting is that we meet each other whenever we go to the conferences that are mostly in the U.S. Sometimes it's much easier to meet them in the States rather than in Israel.
Yeah, but it's interesting, the Israel entrepreneurial culture, but obviously I think Israel in some ways modeled in the U.S. in that way, that aspect. But, people even in the West Bank are building businesses, and they're thinking about their IP rights as they're doing business in Israel. And not that they're only thinking about it, but they want to make sure that they protect their rights and taking a step to do that in the midst of everything. So that's cool. Any one of those, I don't know, maybe you can go into details, but any one of those stories that kind of stick out to you about helping a business there? Or
so sometimes, let's say we have an infringement. We found out that part of the work with trademarks is anti-counterfeiting, meaning that we enforce the rights of the trademark in the Israeli customs. So sometimes the infringements comes from China, and sometimes they're produced in the West Bank. So in some cases, we engaged our colleagues to send cease and desist letters against infringers, and also litigate cases against infringers in the West Bank. And vice versa, we handled cases in the trademark office. We had quite a long and quite costly trademark case on behalf of that we served their client in Israel. Yeah, it's a very fruitful cooperation between our firm and our colleague in the West Bank.
Let's say there's infringement in the West Bank, somebody's making products there. How effective is it to send, from your experience,
a cease and desist letter? You're saying
letter
if
or
it would be any
yeah.
enforcement. So right now, during the war, the chances are very low. But whenever, let's say, before the war, we had a good success. We had good cases, and we managed to stop infringements in some areas in the West Bank.
Yeah, that's interesting. That I guess, to put it mildly, not everything is going well there, but IP enforcement was a
sometimes
possibility. Yeah. Ariel, well, thank you so much. Somebody might be listening to this and they're like, "That's very cool. The practice that Ariel built, working with entrepreneurs, people just starting out, and helping with trademarks." And you said you started a big firm. Any advice to somebody who wants to do what you do, have their own firm?
My advice is to be friendly, to publish articles, to provide as much as information that you can about the field. Do whatever you can to cooperate with colleagues, provide as much as information as you can, and make friends, and business will follow. That's my slogan. That's my advice. It's not my own slogan. I don't have copyright for that, of course.
Well, that's great advice and a great moment to end on. Thank you so much, Ariel.
Thank you so much. Thank you.
Thank you so much for listening. New episodes of Clause 8 come out every 2 weeks, so be sure not to miss it by subscribing at clause8podcast.com.